You can't treat your apartment like an individual bungalow.
So we can take that, and a lawyer such as yourself will work on that, or will you start from scratch?
It's not just the 4 walls that you're buying, but that entire 20 acre becomes very important to you.
So we've talked about why due diligence is required. Okay, I will let you take the ball.
So I think I was talking about how there needs to be coordination or a synchronization between the title documents and the revenue documents. So we do look at the RTC. So RTC gives us a lot of information about revenue and what has happened, etc. Then we also move on to MR, something called MR, which is a mutation register extract, where every time there is a transfer that takes place, you have to get that transfer mutated before the revenue authorities.
Okay.
That's a very important step.
So this is the individual homeowner buyer
This
needs
is
to
in any land.
Okay.
So this is the check that we do.
So you're talking about land now. You're not talking
We're
about...
not there yet. So
yeah.
we first finish the land. First we need to establish that the land is clear. And then we look at how the building that is constructed on the land has all the permissions.
Got it.
So land is very essential. And we also look at MR, which is mutation register. Then we look at something called the Akarband, which is also a document which tells you the extent of land, how much Kharab is there. There are 2 kinds of Kharab, A and B. RTC also discloses this. Akarband also discloses this. So we will see if that is also in sync. And A Kharab essentially means you can transfer it, you can get that converted. B Kharab belongs to the government. There are different types of Kharab. There's like this called Goma land, which is, it's called Goma land. It used to be cow shed, which again belongs to the government. So there are different types of land where, which sort of is B Kharab and government lands, and you cannot buy them. So that's also essential. Along with that, we also look at the village map, which indicates whether there was a lake, whether there was, they say 𝗲𝗅𝗴𝗶 and different kinds of pathways.
How back in history do you go? Because over a period of time, things change, right? Even if you just look at where we are in South Bangalore, if you were to look at 50 years, 60 years, 70 years back, there were a lot of lakes, and things have changed. So at what point...
If there was a lake in the village, that lake ought to be there even today. It may physically not be there, but that demarcation is there, then it's a red flag.
Okay.
So that's very essential, because the law today says that, look, if it is part of your village map and if it's already there in existence, you may have done something about it today. But the fact that it's there and it's reflecting there, which means that tomorrow any permissions that have to be given to you will be based on that.
Okay.
So you can't overcome that. And today at least what I personally do is I look at documents from 1960, because that's when the RTCs are available. So because we have documents that are available, then why do you want to miss it? You can very conveniently say, no, I'll just look at 30 years, maybe let's start from 1980s. You can do that, but unfortunately documents are available. Okay. So when documents are available, you can't say, I'm not going to look at it.
Okay.
So essentially...
So it's better to be safe than sorry. So.
Absolutely.
Okay. Please, go ahead.
So we also look at the village map to see what encumbrances are there, what kind of property, how is your site description, all of that. And after that, we also look at encumbrance certificate. What does encumbrance certificate mean? It shows that whether your land was encumbered. Did you mortgage the land? That's something it reflects, because most of your mortgage deeds have to be registered. So mortgage sort of comes, any sale that happens, any charge that is created on the property. Usually encumbrance certificate reflects all of this. So in fact, the first document we look at, once we look at all the title, is the encumbrance, to see if
there is
the transfer is reflecting in the encumbrance, and also is there something that the encumbrance certificate is reflecting, which documents we don't have. So like I said, it also is a revenue record, which means that we have to see that it's all in sync.
So if somebody was to sell, say I have an apartment today and I have a loan or a mortgage on that, and I sell it, I no longer am encumbered because I've sold that property, but it is passed on to the buyer now. So even the seller has to be aware of that encumbrance being cancelled, isn't it?
Yes. So the only way a mortgage can get redeemed or cancelled is there's another registration that happens.
Correct.
So when you look at the encumbrance certificate, if the encumbrance certificate is reflecting that there is a mortgage, then subsequently there's a redemption as well. That is shown. So if there is a cancellation or redemption of that mortgage, then essentially means that there is no mortgage on the property today. A lot of times companies, a lot of builders, right, sometimes they create charge, which gets reflected before the Ministry of Corporate Affairs. You have to file a charge form. That's also a check that we do if you're buying it from the builder to ensure, or we let them know, because builders will create a charge. They are mortgaging the land, but it's essential you take an indemnity from them to protect. I mean, they will tell you that of course we're going to discharge once we sell all the properties, but you need that guarantee because you're investing much before the mortgage is redeemed or the charge has been removed. So it's essential that, if you're buying it from a company, then you also do a charge, a pledge, and all those checks before the Ministry of Corporate, because these are public documents. And the minute, and even the documents that I'm talking about, the title, the revenue, these are all public documents. So there is no way you can tomorrow say, no, I didn't
wasn't
know.
aware of it. Yes.
You can't take that defense, right? So those are the checks that we do in terms of land.
Got it. So this is in terms of land. There is also a case that you can't convert agricultural land to, any other purposes.
That's
right?
a good point.
So if that comes up, or should you take care of that?
So you can convert. Agricultural lands can be converted. What you can't convert is lands that are on the green zone.
Okay.
Forest lands. These are lands that you cannot convert. Again, how do we know this? We look at village maps. We see where it's demarcated. Today, if you were to buy a property in the urban area, then we look at the CDP, which is your Comprehensive Development Plan.
CDP, Comprehensive Development Plan.
And Revised Master Plan. That's, currently the 2015 document is in existence. The 2031 document is challenged. There's a revision, but that's been challenged before the court, so we're still looking at the 15. So there also we looked at the zoning. So every land there is a zoning. Is it a mixed? Mixed is between residential, commercial. Is it only commercial? Is it industrial? This is something that you can get out of the CDP if you're looking at the urban part of it. If it's agricultural, a lot of agricultural lands can be converted directly, which means you do a conversion order, which is given by your Deputy Commissioner, DC. Some lands also need, the nature of the land itself needs to be changed because they are still in the agricultural zone, which means you can't directly convert them. So you'll have to do a change of land use first. And once the change of land use is done, then you can do a conversion from agricultural to residential, commercial, whatever that is, depending on, again, the zoning and the permissibility of the zoning. That's how it works.
So now we've looked at land.
So it's one more point that I want to address is that if you don't have conversion from agricultural to residential, generally in normal parlance, it's called revenue sites. When you hear the word revenue site, what they essentially mean is that the zoning has changed. So I can build a residential house or apartment or something here, but the conversion is not done.
Okay.
And therefore your property becomes a 𝗖𝗵𝗲𝗃 property. Okay. So there's also 𝗖𝗵𝗲𝗃 and 𝗖𝗵𝗃. 𝗖𝗵𝗃 is essentially when all your permissions are in order and when everything is clean. 𝗖𝗵𝗃 is when there is a defect. So the defect could be anything. Either it's an additional unsanctioned flaw, that could be a defect, or or the property is constructed on a revenue site. You may not find this with tier 1 or tier 2 builders, but there are smaller apartments where on revenue sites they construct 8 apartments, 10 apartments, and if you're buying those,
you have to be careful.
You have to ensure conversion is done.
Okay. And the onus of conversion is on the builder.
Ideally, but let's say you already bought properties, and what do you do?
And then you have
to work towards. So it's not that you can rectify these defects. In law, it is permissible.
Okay.
So you can get that rectification done if it is a permissible defect, which you can pay penalties, etc. and
get it done.
So let me just conclude on the JDA aspect. So basically, JDA becomes that document where the developer also gets certain rights in the property.
Correct.
Other than just merely developing. Ownership rights, that's what I mean. Now, I was also talking about how they approach architects and get a sanction plan post signing this document, where after the sanction plan gets approved, they know exactly how many apartments they have permissions to construct. Most builders at this particular point get into something called a supplemental agreement or a sharing agreement, where they specify which apartment is going to whom. whether it's falling into the rights of the landowner, rights of the developer. That also becomes very essential. Today, most of the sale deeds are signed by both landowner and developer, so it's the property is getting transferred rightfully, there's no problem there, but that's also another way for us to check as to who's essentially getting a right in this property.
Got it.
Now, that is your first important document when we talk about building. The next thing what we do is, after the ownership right and title, all that is established, the developer generally also signs a power of attorney, a general power of attorney along with his JDA, because the land ownership to a large extent remains with the landowner. And now for the developer to apply for permission and get all the necessary sanctions done, he needs power of attorney. So alongside this JDA, a general power of attorney gets signed where all these powers are given to the developer to sign on behalf of the owner.
So that is also checked.
That's also checked.
Is it important to check that?
Extremely important, because otherwise where is the developer getting these rights from?
So if the GPA is missing, then that means this person has done all these tasks without having the authority.
I'll be very surprised. I've not come across a situation where a GPA is missed.
Okay.
Because it's a very important document. Whenever they go before a revenue authority, that's the first document they ask for.
But if it is missing, then it's a huge problem.
It's a huge problem. It's fairly a problem. Yeah.
Okay.
After that, we look, the next important document that comes across is your sanction plan, where, the construct of your entire apartment, your swimming pool, your STP, all your common areas, all that gets demarcated in terms of where it is supposed to be constructed.
So this is the sanctioned plan.
Sanction plan.
And this also...
It's approved by the municipal corporation, BDA, depending on where it's located.
So this is also...
Planning authority.
This is also important in the RERA aspects of things.
Absolutely. Sanction plan is the first important. If you don't have a sanction plan, then your construction is illegal.
Okay.
It's deemed illegal by law.
Okay.
The sanction plan is 100% necessary. This is for any construction.
Got it.
Be it an apartment, an independent house, etc. Anybody needs a sanction plan to put up construction.
Got it.
Once we look at the sanction plan, a lot of things actually gets crystallized. And then we look at other aspects. Whether they have, depending again on the size, where they're located. Let's say they're located near a metro line. Metro, BMR, CL needs to give you NOC, BWSSB, BESCOM, all these power authorities, water, all of them need to give you NOC, no objection for you to construct.
So there are a lot of NOCs that are in
A lot of NOCs.
So do you also look at all the
Absolutely,
NOCs? Okay.
Absolutely. We look at that. Then we also look at STP permission, then your power connection permission. If it's larger building, transformers are there, whether you've gotten the necessary permission to put up a transformer. So everything that you're going to construct, you need permission to construct. All the common areas, right? Especially equipments and things like that, for you to place them, you need permission. So we look at all those permissions to see if it's, if it's a large extent of land, then you'll also need, environment clearance. So it really depends. So some smaller properties don't need exhaustive list of permission, but the larger the landscape is, more permissions are required. Another important aspect that I forgot.
A lot of cases we've seen, recently in Bangalore, we've seen that there was a forged occupancy certificate.
When you're booking an apartment, will never give you original documents. Only when you're doing a photo, like a handover.
Do you also look at the statutory requirements?